The Landlord and Tenant Board can give you information about your rights and responsibilities to help you solve tenancy problems and disagreements on your own. If you can't solve the problems on your own, you can file an application with the board. The board can make a decision about many landlord and tenant matters under the Residential Tenancies Act. Once an application is filed, the board will schedule a hearing. At the hearing, a board member will make a decision based on the information given by the landlord and tenant and what the law says. Instead of going to a hearing, the parties can try board mediation to solve their tenancy problems. Mediation is a free service offered by the board. In mediation, a board mediator helps the landlord and tenant talk about tenancy problems and come up with their own solutions. Mediation can also resolve other tenancy problems that were not part of the application. Mediation usually happens on the same day as the hearing. In most cases, a mediator is available to help you on the day of your hearing. You can also call the board and ask for mediation before the hearing date. Mediation is voluntary, so you do not have to try mediation, but it may help solve your problems without going to the hearing. Mediation with the board is an informal process. The mediator helps both parties and doesn't take sides. Mediation is private and confidential. Anything that is said during mediation is not shared with anyone else, and no information is kept by the board after mediation finishes. If mediation is not successful, nothing said during mediation can be mentioned at the hearing. Although mediation is private, you can bring a friend, relative, social or support worker, or a legal representative to help you if you think you need this help. A mediator is not a board member. They don't make the decisions for you. They are there to help you and the other party talk about your tenancy problems and come to your own agreement. Mediators can provide information about the law, but will not provide legal advice. The mediator will explain how mediation works, help you focus your discussion on your tenancy problems, and reach an agreement. The mediator also makes sure that the discussion runs smoothly, that everyone has the opportunity to speak without being interrupted, and that everyone treats each other with respect. Sometimes it helps to talk to each party alone. This is called a caucus. Information the mediator gets from one person will be shared with the other person unless the mediator is told specifically not to. Mediation is a win-win situation. It gives both the landlord and the tenant the chance to talk, have their say, and agree on a solution to their tenancy problems. If an agreement is reached, the mediator will write it down and both the landlord and tenant will sign it. The agreement is confidential. Only you and the other person get a copy. The board does not keep a copy. A mediation agreement is legally binding. If one person doesn't follow what was agreed to, the other person can ask to have the application reopened and heard by a member. If an eviction application was mediated, then under the agreement, the landlord may be allowed to request an eviction order without a hearing. In most cases, mediation at the board is successful. However, mediation is voluntary, and it can be ended at any time by the landlord or tenant. If you are mediating on the day of the hearing and you don't reach an agreement, your hearing will generally proceed that day, time permitting. Mediation is a good alternative to a hearing. It helps parties talk openly and solve their own tenancy problems. Mediation can improve the landlord and tenant relationship, so you resolve any future problems on your own. Mediation can help you.